I honestly do not believe that my client should be considered a menace to other juveniles. This is someone who has never been in trouble before. This is not someone who has a history of assaulting kids his age or any other negative contact with his peers. This one isolated incident is all that we're looking at here today.
Judge, this cannot be compared to any other case that this court or any court in this county has seen before. And calling this an isolated incident, quite frankly, does not do it justice. This was a mass murder at a school, Judge. This was planned. It was premeditated. The evidence that we have and that we discussed at the arraignment showed it was premeditated for a period of time before it was commenced.
Mr. Crumbley, did you hear and understand what your attorney just stated?
Yes, ma'am.
And are you in agreement with that?
Yes.
So you're not waiving, of course, your right to a preliminary exam, just the right to have it heard within the statutory time period. And that is, of course, so your attorney can properly prepare for a preliminary exam if one is necessary. Again, do you understand and agree to that?
Yes, ma'am.
I do find good cause to waive that statutory time period. I will adjourn the probable cause conference to January 7th at 9 a.m.
Calling docket number 21006-652, People versus Jennifer Crumbley, and docket number 21006-651, People versus James Crumbley.
This case is unprecedented in Oakland County and perhaps the state. It is unlike any other case, and given that we submit that the typical protocols for discovery and the normal timeframes for a preliminary examination will not allow adequate time for the prosecution or the defense, for that matter, to adequately prepare.
And are you willing to waive that right?
That's right.
Okay. The court will go ahead and reset the preliminary examination for February 8th at 1:15.
And we were certainly not going to arrange meetings to prepare for litigation while these children were being buried and this community is trying to heal.